All right, before we move on, if you watch part one, there's some explanations that are needed up in here. So we'll come back down here to chapter 5 and start out with presentment. But we need to get back up here so you understand some very important things here. Let's just do it this way. All right. We started out in video 1 of interpretations of the clauses, right? And we get right here to accommodation party. All right, you're accommodating party. If you don't rebut and rebuke that you're the accommodating party, you're the one that's liable on the instrument, okay? We are not ever an accommodating party. This right here, B, banker, means a person transacting the business of accepting for the purpose of lending or investment of deposits of money from the public, repayable on demand or otherwise, and withdrawable by check, draft, or order or otherwise, and includes any post office savings bank. Ladies and gentlemen, you are private bankers, and the instruments that you are creating that people are investing in, all right, or lending, okay? So you're lending your life source energy, your time valued commodity on an instrument known as a negotiable instrument, a bill of exchange, a draft, a banker's acceptance, a trade acceptance, a check, a promissory note, okay? And you are the maker and the creator of said instrument, which means you're the private banker. And what they're doing is they're negotiating your private intellectual property without telling you that they're going to shop around your negotiable instrument to the highest bidder. And so they're taking your credit from the Social Security account, all right? And then they're turning around and they're shopping around your instrument to see, based upon your credit worthiness, to see who's going to buy it, all right? And then your agent receives a check at discount, because they typically sell it, your negotiable instrument, your over-the-counter security, at a discounted rate. But they never tell you that they're going to do these things, all right? Full disclosure is never had. And because of that, you're led to believe that you are a borrower, when in fact you are the lender, okay? And they're converting you into a non-disclosed third-party investor, ladies and gentlemen. And you have to rebut and rebuke that. You're not the investor. You are not the borrower. You are not an accommodating party. You are, in fact, the issuer of the original source issue that has all the value, and you are rightfully due and owing anything that was made from that note. Okay, so you're the banker that predominantly lends or extends instruments that people can invest in. All right, and that's important to know. Let's get back down here to the good stuff, because we're just getting into presentment. And again, this comes from the Act of 1881, enacted in 1882. And try and do this without making you guys go crazy. Let's see here. Super important that people understand this. I don't see anybody on the internet speaking about it from America per se, which is kind of disheartening, because it is a very, very important part of our history, economically speaking. So now we're going to get into presentment. We're going to go into it pretty deep. Later on, I'll come back and capitalize on it. This is what I do for research before I build my classes, as I read all this information, and then I find out how it applies. Then I put it into a comprehensive class for you guys, and with your participation and willingness to donate to the class, I'm able to put these classes together in a comprehensive form. I'm not a lawyer. I never went to data law school. For all intents and purposes, as far as paper is concerned, I am not educated in the slightest. However, I have had a tremendous amount of success in court and outside of court settling people's affairs, okay? Because I take the time to read and ascend of the mind and comprehend what is really going on. So this is chapter 5 of presentments, presentment for acceptance. 61. A bill of exchange payable after sight must, if no time or place is specified therein for presentment, be presented to the drawee thereof for acceptance. If he can, after reasonable search, be found by a person entitled to demand acceptance within a reasonable time after it is drawn, and in business hours on a business day, in default of such presentment, no party thereto is liable thereon to the person making such default. If the drawee cannot, after reasonable search, be found, the bill is dishonored. If the bill is directed to the drawee at a particular place, it must be presented at that place, and if at the due date for presentment he cannot, after reasonable search, be found there, the bill is dishonored. Where authorized by a agreement or usage, a presentment through the post office by means of a registered letter is sufficient. Presentment of a promissory note for sight. 62. A promissory note payable at a certain period after sight must be presented to the maker thereof for sight, if he can, after reasonable search, be found by a person entitled to demand payment within a reasonable time after it is made, and in business hours on a business day. In default of such presentment, no party thereto is liable thereon to the person making such default. Drawee's time for deliberation. 63. The holder must, if so required by the drawee of a bill of exchange presented to him for acceptance, allow the drawee 48 hours exclusive of public holidays to consider whether he will accept it. Presentment for payment. 64. Subject to the provisions of Section 76, promissory notes, bills of exchange, and checks must be presented for payment to the maker, acceptor, or drawee thereof respectively, by or on behalf of the holder as hereinafter provided. In default of such presentment, the other parties thereto are not liable thereon to such holder. Exceptions. Where a promissory note is payable on demand and is not payable at a specific place, no presentment is necessary in order to charge the maker thereof, nor is presentment necessary to charge the acceptor of a bill of exchange. The provisions of this section are without prejudice to the provisions relating to presentment or acceptance in the case of a bill of exchange. Explanation. Where there are several persons, not being partners, liable on the negotiable instrument as makers, acceptors, or drawees, as the case may be, and no place of payment is specified, presentment must be made to all of them, to them all. Hours for presentment. 65. Presentment for payment must be made during the usual hours of business, and if at a banker's within banking hours. Presentment for payment of instrument payable after date or sight. 66. A promissory note or a bill of exchange made payable at a specified period after date or sight thereof must be presented for payment at maturity. Presentment for payment of promissory note payable by installments. A promissory note payable by installments must be presented for payment on the third day after the date fixed for payment of each installment, and non-payment on such presentment has the same effect as non-payment of a note at maturity. The presentment for payment of instrument payable at specified place and not elsewhere. The promissory note, bill of exchange, or check made, drawn, or accepted payable at a specified place and not elsewhere must, in order to charge any party thereto, be presented for payment at that place. Instrument payable at specified place. A promissory note, bill of exchange made, drawn, or accepted payable at a specified place must, in order to charge the maker or drawer thereof, be presented for payment at that place. Presentment where no exclusive place specified. A promissory note or bill of exchange not made payable as mentioned in section 68 or 69 must be presented for payment at the address of the maker, acceptor, or drawee given in the instrument, and if no such address is given, at the place of business if known, or at the ordinary residence if known, of the maker, drawee, or acceptor thereof, as the case may be. Presentment when maker, etc., has no place of known business or residence. If the maker, drawee, or acceptor of a negotiable instrument has no known place of business or residence, and no place is specified in the instrument for presentment, for acceptance, or payment, such presentment may be made to him in person wherever he can be found. Explanation in this section and section 68 and 69, specified place, means a place sufficiently described so as to enable the person presenting the instrument to locate it. What constitutes valid presentment and mode of presentment? 71. To constitute a valid presentment, it shall be sufficient if, instead of the original negotiable instrument, a copy thereof, certified to be true by the holder, is delivered to the person liable thereon, either personally or by registered post or by other effective means. 2. If after such delivery the person liable to pay so demands, the holder shall allow him to inspect the original negotiable instrument during the hours of business of the holder, and if the holder fails to do so within a reasonable time, the presentment shall be deemed to be invalid. That's Federal Rules of Evidence 1002, ladies and gentlemen. Write that down. Presentment of the check to charge drawer. 72. Subject to the provisions of Section 84, a check must, in order to charge the drawer, be presented at the bank upon which it is drawn before the relation between the drawer and his banker has been altered to the prejudice of the drawer. Presentment of a check to charge any other person. A check must, in order to charge any other person except the drawer, be presented within a reasonable time after delivery thereof by such person. Presentment of instruments payable on demand. 74. Subject to the provisions of sections 31, a negotiable instrument payable on demand must be presented for payment within a reasonable time after it is received by a holder. Presentment by or to agent representative of deceased or assignee of insolvent. Presentment to acceptance for presentment 75. Presentment for acceptance or payment may be made to the duly authorized agent of the drawee, maker, or acceptor, as the case may be, or where the drawee, maker, or acceptor has died, to his legal representative, or where he has been declared an insolvent, to his assignee. Excuse for delay in presentment for acceptance or payment. 75A. Delay in presentment for acceptance or payment is excused if the delay is caused by circumstances beyond the control of the holder and not imputable to his default, misconduct, or negligence. When the cause of delay ceases to operate, presentment must be made within a reasonable time. When presentment unnecessary. No presentment for payment is necessary, and the instrument shall be deemed to be dishonored at the due date for presentment in any of the following cases. A. If the maker, drawee, or acceptor intentionally prevents the presentment of the instrument, or if the instrument being payable at his place of business, he closes such place of business day during the usual business hours, or if the instrument being payable at some other specified place, neither he nor any person authorized to pay it attends at such place during the usual business hours, or if the instrument not being payable at any specified place, he cannot after due search be found. B. As against any party sought to be charged therewith, if he has engaged to pay notwithstanding non-presentment. C. As against any party, if any maturity with knowledge that the instrument has not been presented, he makes a part payment on account of the amount due on the instrument, or promises to pay the amount due thereon in whole or in part, or otherwise waives his right to take advantage of any default in presentment for payment. D. As against the drawer, if the drawer could not suffer damage from want of such presentment. E. Where the drawee is a fictitious person. F. As regarded an endorser, where the negotiable instrument was made, drawn, or accepted for the accommodation of that endorser, and he had reason to expect that the instrument would not be paid if presented. And G. Where after the exercise of reasonable diligence, presentment as required by this act cannot be effected. Explanation. The fact that that holder has reason to believe that the negotiable instrument will, on presentment, be dishonored does not dispense with the necessity for presentment. Liability of banker for negligently dealing with bill presented for payment. 77. When a bill of exchange accepted payable at a specified bank has been duly presented therefore payment and dishonored, if the banker so negligently or improperly keeps, deals with, or delivers back such bill as to cause loss to the holder, he must compensate the holder for such loss. Chapter 6 of Payment and Interest, to whom payment should. 78. Subject to the provisions of Section 82, Clause C, payment of the amount due on a promissory note, bill of exchange, or check be made must in order to discharge the maker or acceptor be made to the holder of the instrument. Instruments, when rates specified or not specified. 79. Subject to the provisions of any law for the time being in force relating to the relief of debtors and without prejudice to the provisions of sections 34 of the Code of Civil Procedures 1908. A. When interest at a specified rate is expressly made payable on a promissory note or a bill of exchange and no date is fixed from which interest is to be paid, interest shall be calculated at the rate specified on the amount of the principal money due thereon from the date of the note, or in the case of a bill, from the date on which the amount becomes payable until tender or realization of such amount, or until the date of the institution of a suit to recover such amount. B. When a promissory note or a bill of exchange is silent as regards interest or does not specify the rate of interest, interest on the amount of the principal money due thereon shall, notwithstanding any collateral agreement relating to interest between any parties to the instrument, be allowed and calculated at the rate of 6 percentum per annum, 6 percentum per annum from the date of the note, or in the case of bill, from the date on which the amount becomes payable until tender or realization of the amount due thereon, or until the date of the institution of a suit to recover such amount. Interest when no rate specified. When no rate of interest is specified in the instrument, interest on the amount due thereon shall, notwithstanding any agreement relating to the interest between any parties to the instrument, be calculated at the rate of 6 percentum per annum from the date at which the same ought to have been paid by the party charged until tender or realization of the amount due thereon, or until such date after the institution of suit to recover such amount as the court directs. Explanation. When the party charged is the endorser of an instrument dishonored by non-payment, he is liable to pay interest only from the time that he received notice of the dishonor. Delivery of instrument on payment or indemnity in case of loss. 81. Any person liable to pay and called upon by the holder thereof to pay the amount due on a promissory note, bill of exchange, or check is before payment entitled to have it shown and is on payment entitled to have it delivered up to him, or if the instrument is lost or cannot be produced, to be indemnified against any further claim thereon against him. Chapter 7 of Discharge from Liability on Notes, Bills, and Checks. Discharge from liability. 82. The maker, acceptor, or endorser, respectively, of a negotiable instrument is discharged from liability thereon, A, by cancellation. To a holder thereof who cancels such acceptor's or endorser's name with intent to discharge him, and to all parties claiming under such holder. B, by release. To a holder thereof who otherwise discharges such maker, acceptor, or endorser, and to all parties deriving title under such holder after notice of such discharge. And C, by payment. To all parties thereto, if the instrument is payable to bearer or has been endorsed in blank, and such maker, acceptor, or endorser makes payment in due course of the amount due thereon. Discharge by allowing drawee more than 48 hours to accept. 83. If the holder of a bill of exchange allows the drawee more than 48 hours exclusive of public holidays to consider whether he will accept the same, all previous parties not consenting to such allowance are thereby discharged from liability to such holder. when checks not duly presented and drawer damaged thereby. 84. Where a check is not presented for payment within a reasonable time of its issue, and if the drawer, and the drawer or person on whose account it is drawn had the right at the time when presentment ought to have been made, as between himself and the banker, to have the check paid, and suffers actual damages through the delay, he is discharged to the extent of such damages, that is to say, to the extent to which such drawer or person is a creditor of the banker, to a larger amount than he would have been if such check had been paid. 2. In determining that what is a reasonable time, regard shall be had to the nature of the instrument, the usage of the trade, and the bank and of bankers, and the facts of the particular case. 3. The holder of the check, as to which such drawer or person is so discharged, shall be a creditor in lieu of such drawer or person of such banker to the extent of such discharge, and entitled to recover the amount for him. Illustration: A drawers a check for Taka 1000, and when the check ought to be presented has funds at the bank to meet it, the bank fails before the check is presented. The drawer is discharged, but the holder can prove against the bank for the amount of the check. B. A drawers a check at 13 on a bank of Chittagong. The bank fails before the check could be presented in ordinary course. A is on discharge, for he has not suffered actual damage through any delay in presenting the check. Check payable to order. Where a check payable to order purports to be endorsed by or on behalf of the payee, the drawee is discharged by payment in due course. 2. Where a check is originally expressed to be payable to bearer, the drawee is discharged by payment in due course to the bearer thereof, notwithstanding any endorsement, whether in full or in blank, appearing thereon, and notwithstanding that any such endorsement purports to restrict or exclude further negotiation. Drafts drawn by one branch of a bank on another payable to order. 85A. Where any draft that is an order to pay money drawn by one office of a bank upon another office of the same bank for a sum of money payable to order on demand purports to be endorsed by or on behalf of the payee, the bank is discharged by payment in due course. Parties not consenting discharged by qualified or limited acceptance. 86. If the holder of a bill of exchange acquiesces in a qualified acceptance, or one limited to part of the sum mentioned in the bill, or which substitutes a different place or time for payment, or which where the drawees are not partners, is not signed by all the drawees, all previous parties who consent is not obtained to such acceptance are discharged as against the holder and the claim under him, and those claims under him, unless on notice given by the holder they assent to such acceptance. Explanation: an acceptance is qualified. A. Where it is conditional, declaring the payment to be dependent on the happening of an event therein stated. B. Where it undertakes the payment of part only of the sum ordered to be paid. And C. Where no place of payment being specified on the order, it undertakes the payment at a specified place and not otherwise or elsewhere, or where a place of payment being specified in the order it undertakes the payment at some other place and not otherwise or else. And D. Where it undertakes the payment at a time other than that at which under the order it would be legally due. Effect of material alteration. Any material alteration of a negotiable instrument renders the same void as against anyone who is a party thereto at the time of the making such alteration and does not consent thereto, unless it was made in order to carry out the common intentions of the original parties. Alteration by endorsee. And any such alteration, if made by an endorsee, discharges his endorser from all liability to him in respect of the consideration thereof. The provisions of this section are subject to those of sections 20 and 49, 86, and 125. Acceptor of endorser bound notwithstanding previous alterations. 88. An acceptor or endorser of a negotiable instrument is bound by his acceptance or endorsement notwithstanding any previous alteration of the instrument. Payment of instrument on which alteration is not apparent. Where a promissory note, bill of exchange, or check has been materially altered but does not appear to have been so altered, or where a check is presented for payment which does not at the time of presentation appear to be crossed or to have had a crossing which has been obliterated, payment thereof by a person or banker liable to pay and paying the same according to the apparent tenor thereof at the time of payment and otherwise in due course shall discharge such person or banker from all liability thereon, and such payment shall not be questioned by reason of the instrument having been altered or the check crossed. Extinguishment of right of action on a bill in acceptor's hands. 90. The maker, drawer, acceptor, or endorser of a negotiable instrument is discharged from liability thereon when the person liable thereon as principal debtor becomes the holder thereof at or after its maturity. 2. When a holder of an accepted bill of exchange enters into any contract with the acceptor of the nature referred to in sections 39, the other parties are discharged unless the holder has expressly reserved his rights to charge them. Chapter 8 of Notice of Dishonor. When we come back, we'll be getting into Chapter 8, Notice of Dishonor. Thanks for joining me. We'll try and keep this short.